Hello YouTube, I'm Vince White. I'm an employment attorney. On this channel, we answer publicly posted questions from YouTube users, getting folks the answer they need from an employment attorney. We have a question here from YouTube user Charles Johnstone, and yes, we are working on the clicking. We hired we're working with a couple of very smart people, including one fan of the channel, to search for the gremlin in the sound system and get rid of the clicking. Basically, we went ahead and right now, I use a Blue Yeti like USB microphone for this and a webcam. And that's generally fine, I think. It's worked well-ish for us over the years. But there we go. It isn't working anymore because it's introduced this clicking sound into the videos. And so we are starting piece by piece to upgrade the setup here in the studio. We have a professional mic coming and a professional, I don't know, box, like for real microphones that will take the microphone actual inputs, not the USB inputs, and like translate them to the computer. As I speak about this, it should be very clear. I don't know what I'm doing. I'm not a talented technical person. I am not a sound engineer. I am not a great and knowledgeable user of computers besides video games. Okay, now back to the question. We have a question here from YouTube user Charles Johnstone, who is an OG from the channel. He's been posting on that channel for years, 3-4 years now, I don't know. And Charles asks us, Vince, did you see the huge news today? Huge! Emphasis me. New York State extended the discrimination statute of limitations from 1 year to 3 years. False, but I understand what he means. We'll explain what he means. Does this mean that you can also file with the EEOC within 3 years instead of the 300 days since they have a work sharing agreement? Okay. So, Charles is referencing the New York State Human Rights Law. And the New York State Human Rights Law is the state law in New York State, all of New York State, that addresses workplace discrimination, workplace sexual harassment. Do not confuse this with the New York City Human Rights Law, which is similar but different and has a couple of advantages over the New York State Human Rights Law. Remember, if you have the opportunity to plead them both, you should, generally speaking. Okay, now, the statute of limitations for both the New York State and the New York City Human Rights Law, when filed in a state or federal court, was always 3 years. So Charles is not referencing that. What he's specifically referencing is that previously, when you filed the New York State Human Rights Law with the state agency, the State 706 agency, the New York State Division of Human Rights, the old statute of limitations was 365 days. Now, under that scenario, the EEOC statute of limitations within New York State was 300 days because, of course, the statute that creates the EEOC is designed, built, drafted to harm plaintiffs. The way the statute of limitations for the EEOC works is that in a state where there is no qualifying state agency that deals with workplace discrimination, workplace sexual harassment, these are called 706 agencies. In a state where no such agency exists, the statute of limitations for the EEOC is 180 days. And the EEOC will keep a list for you as to which states have qualifying agencies and which do not. Now, in a state where such an agency does exist, the EEOC statute of limitations is 300 days. And of course, I say that both those statute of limitations are ridiculously short, as is the 365-day statute of limitation to get filed in the State Division of Human Rights. Human beings, when they process trauma, simply do not move fast. It takes time. When you've been through a lot, and if it involves your job, and being attacked on the basis of your very identity, which is what most, if not all, protected classes equate to, it's going to be traumatic, right? Like, your job is how you put a roof over your head, feed your family, stay alive. So when people are like, you're just being fired, it's not that big a deal. No. The means by which you survive in a nation with very little safety net has been impacted. And so it is always a big deal, right? It's also a sense of identity and pride. your job. And so simultaneously, your ability to survive, your identity, and a source of pride are being stripped from you when you're being terminated, right? Now, that means it's traumatic. That means it's going to take time. And so if you want to file a federal lawsuit, bringing federal claims, generally speaking, there's some claims that don't have to go through the EEOC for workplace discrimination. There's some, but the most valuable and generally the most widely used and the easiest to use and perhaps the most powerful all have to go through the EEOC. And you need to file with the EEOC within either 180 or 300 days to get the EEOC to issue a right to sue letter. The EEOC will issue this right to sue letter, which gives you access to filing your claims in federal court. Great. If you miss the EEOC filing, then your Title VII claims and a variety of others, including your ADA claims and various statutes that the EEOC adjudicates, those claims on the federal level will actually be extinguished. They will not be something you can pursue in federal court, believe it or not. Shockingly, bizarrely. Now, this entire process exists purely to extinguish claims. Like, this is an agency that was initially created to harm employees. It now tries really hard to masquerade, sometimes legitimately, as an agency that helps employees. Of course, and we have videos on the channel, not all EEOC investigators are created equal, and the data out of the EEOC in terms of what they do for employees is pretty disheartening. We have a video about that as well. Now, those two statutes of limitations for the EEOC are set by federal statute, right? The Congress of the United States has written down a law and voted it in, and that's the law that sets the statute of limitations for the EEOC. So, as Charles asked, and I'll read that part of his question again, does this mean that you can also file with the EEOC within 3 years instead of the 300 days since they have a work-sharing agreement with the State Division of Human Rights? No. The ability to file with the State Division of Human Rights has been extended from 365 days to 3 years. And that's swell. It gives you more ability if you want to file on a private docket where you're not going to show up on Google, you're not going to show up on background checks. It gives you more ability to bring that case in the State Division of Human Rights instead of having to file in state or federal court with that claim. And that's swell. But the state legislature of New York does not have the ability to modify or create laws for the federal government. Simply not how it works, and Charles knows this. And Charles is not saying, like, oh, can the state government of New York change the federal laws? That's not what he's saying. What he's actually saying is, hey, there's a work-sharing agreement between the two agencies, the federal and the state. Does that work-sharing agreement work in some way to extend the EEOC statute of limitations? Unfortunately, the answer is just no. No, it does not. So now, this cough, my God. Now you're going to have claims that are getting filed in the State Division of Human Rights that do not have corresponding EEOC filings because they've timed out. They've gone past 300 days since the last act of discrimination or retaliation. And that's good that you can still file them in the state agency. But it is a major and tremendous disadvantage when you lose your federal claims. The federal claims have certain advantages. They allow certain tactical moves. They allow certain little clever plays and end runs that you can engage in that the state law doesn't necessarily in certain scenarios. So Charles, while I'm ecstatic, as you are, about the extension of the ability to bring the New York State human rights law claims in the agency, the New York State Division of Human Rights, for up to 3 years now, it's not going to change the EEOC. And that stinks quite a bit. But you ask great questions, Charles. It's always good to hear from you. I hope all is well. and I wish you good things and great success. If this was helpful, like, subscribe, comment down below. Helps our channel to grow. And if it was not, I recommend hitting the thumbs down button and writing a mean comment. Like, if you could express how much you hate us, I would appreciate that a lot, because every comment helps. Take care, everybody. And hit that thumbs down. Do it. I mean, or thumbs up. If you're happy and you like us, thumbs up's cool too. But if you don't, if you're mad, mad, thumbs down, baby. Let's do it. Let's make it happen. All right. Take care.